New York office of, uh, of our firm, and I'm also a partner in the White Collar Crime Practice Group. And again, welcome to today's webinar. This is the second in a series of two webinars highlighting what we see as enforcement and compliance risks as the new administration comes in and gets settled and begins to articulate and act on its white-collar crime enforcement priorities. We're going to try and figure out what actually those are and see what can be done to deal with them. I want first to address a few procedural items. First, and for some this is perhaps the most important item, is how to obtain CLE credit for your participation today. You have received two forms. One is an attorney affirmation for non-traditional course format form, and a second one, a feedback form. Please send both completed forms to Brittany Counts in order for you to receive CLE credit. Brittany's email address is contained on the forms, and please note that you do not you do need to list the CLE codes, which will be given throughout the presentation to receive the credit, and we will put them up on the screen and also say them in case you're not looking at the screen at the moment they come up. Second, today's program is being recorded, and we will send a link to all of you with the recording and the presentation slides as well within 48 hours of the presentation, actually either tomorrow or on Monday. And third, if you have any questions during any of the presentations, and we do encourage questions, feel free to use the chat box located in the control panel on the right side of your screen to submit those questions. We will answer those questions during or at the end of the section of the webinar that each one of us is presenting, or offline if there's no time. So last time we covered export controls, FCPA, public corruption and lobbying, and the problem of whistleblowers. Today, we're going to talk about three other white-collar topics. The first is criminal antitrust enforcement. Matt Ridings, who is in our Cleveland office, is a longtime member of the firm, and his specialty is actually competition law, which includes criminal and civil antitrust, and also criminal and civil trade secret law. And because of his diverse expertise, he's been called upon to speak twice. Followed by pound. I will also be speaking about criminal antitrust as well. I'm in, as I said, in the New York office, and I've done a lot of different things over the last decades. And I'm going to be focusing on the criminal side, the specific criminal side of antitrust. Stephen Bloch is going to join Matt for the second presentation. Stephen is in the Chicago office, and he is a former Illinois state prosecutor and also a longtime now a former member of the U.S. Attorney's Office in the Northern District of Illinois. And for the third presentation, which will be on healthcare fraud, we have John Mitchell, who is in our Cleveland office, and he's a former Cuyahoga County prosecutor who has handled and is now handling several federal healthcare fraud cases. He has actually tried one. Sarah Hall, who is also joining him, is in our Washington office, and she is a former federal prosecutor in the fraud section of the Justice Department's Criminal Division. And in her tenure there, she focused much of her attention on healthcare fraud cases, and is now also involved in defending them. So, I'm going to ask Jacqueline if she has the slides up, or can get them up.
Yes, they're up.
Okay, there we go. So the next slide.
I apologize. Someone may need to mute themselves.
is drawn from Syracuse track. Syracuse University has a project to collect information about criminal prosecutions by the federal courts. And on the next slide, please, Jacqueline. Yes, so they obtain information by way of the Freedom of Information Act and file that information. One of the categories that they use for the data is white collar crime. Now, this is drawn from them, and it shows that over the last 5 years, there's been more than a third decline in federal white collar crime prosecutions. Now, there are various issues about defining what a white collar crime prosecution is, what is a prosecution, and obviously this doesn't include investigations, but from a directional point of view, it indicates that there's been a dramatic drop since the end of the Obama administration. The next slide shows the trend over a much longer period of time since actually before the financial crisis. And the blue line is the rolling 6-month average of white collar crime prosecutions, again, only in the federal courts. And if you look at the part of this chart from December of 2008, that is the financial crisis period, the Obama administration is about to enter. And from that point, there is a general upward trend in prosecutions as the financial crisis recedes and cases are brought coming out of that period. Moving forward, cases do start to decline, but when you get to December of 16, which is now over on the right side of the screen, you can see that as the Trump administration comes in, they do not pick up with more white-collar cases as the Obama administration did, and in fact, continue to decline. So if you just look right before the pandemic, which is that big gap on the right, you can see how low the number of cases are relative to the peak of the Obama period. The pandemic obviously put a substantial dent in white-collar cases, with prosecutors working from home and defense lawyers working from home, and courts basically not working at all on the white-collar, on the criminal side. So that accounts for the mid part of 2020, and then things started to pick up again. They don't have more statistics for the first quarter of 2021 yet, but we now have a new administration, and we can expect some increase. There are a number of articles out there by white-collar practitioners. Maybe it's self-optimistic that there will be a change in priorities and increased prosecutions, but it's really hard to tell. Merrick Garland, who is now the Attorney General, during his confirmation hearings, made it clear that domestic terrorism would be a significant priority. And just out of the January 6th riot at the Capitol, there have been already 300 people charged, and that sucks out a large amount of prosecutorial resources, lawyers, agents, and when they're getting those cases ready, and a lot of those cases are, in my view, will likely go to trial because people have a political point they want to make. That's going to take time away from pursuing additional or traditional white-collar cases, such as an FCPA or environmental or tax. So the issue of how much work there is really our problem, not yours. That is those of you who are listening in. But for you, we're going to talk about the opportunities for ways you can take steps to protect yourselves against what we see as some of the things that happened in the last year or so, and what may be happening in the future. So first, as I indicated, we're going to do criminal antitrust, and for that, Matt is going to lead off. Matt?
Thanks, Norman. So I'm going to talk to you about criminal antitrust today, and in order to set the table so you understand what's coming, how this is going to work is, at first I'm going to set the stage and talk about what's happening in criminal antitrust law and the hot topics in criminal antitrust right now. And then for the second part of this presentation, I'm going to shift into a little bit more of a dialogue with Norman, where we're going to talk about how a criminal antitrust investigation might develop from a private company's perspective and how to manage that over the course of your investigation. So as a brief introduction to antitrust law, I'm going to assume that most people are at least sort of familiar with antitrust law, but the antitrust laws exist to ensure a fair marketplace. And what we want to do as a society is to ensure that everyone has a level playing field, because we believe that society benefits from robust competition and that consumers are helped by fair competition and price decreases over time. So the antitrust law covers a lot of different situations, mergers and acquisitions, attempts to monopolize, pricing of products. But you may have seen recently, there's a lot of stuff in the news about the technology companies, Facebook and Google, being subject to antitrust investigation. Those situations are civil antitrust civil antitrust enforcement, not necessarily a criminal prosecution. So only certain types of antitrust conduct, anti-competitive conduct, is prosecuted criminally. Jacqueline, next slide, please. So in order for it to be a criminal antitrust violation, you essentially need to have an agreement with your competitor to do one of a handful of different things. And that is price fixing or wage fixing. That is where you agree with the competitor about the sale or purchase price of a product. Bid rigging, and bid rigging comes in a lot of ways. We're going to talk about this a little bit more in detail later, because bid rigging is a hot topic right now in antitrust. But essentially, it's where you want to agree to the amount of a bid with a competitor. And this can come in a lot of different forms, to where you alternate people that win bids. You agree to submit dummy bids on behalf of the other bidders. But ultimately, it's agreeing with your fellow bidders what the outcome of an auction or a bid system is going to be. Market or customer allocations, where you agree amongst your competitors to divide up markets, to say, I'm going to sell to this person and you're going to sell to that person. Output agreements, where you would say, I'm going to limit how much production I have. This is essentially a form of price fixing, because if you limit your output, prices will tend to rise. And finally, the newest entrant in the criminal antitrust pantheon is no poach agreements. And this is something, again, we're going to talk about in a little bit more detail later, because this is fairly new. This has only been within the last 5 years or so that no poach agreements have been treated as criminally. But this is an arrangement between two or more competitors to not hire each other's employees. And critically, for the no poach agreements, competitor doesn't mean a competitor for the sale of the product that the company is making. How the Department of Justice looks at a competitor with respect to no poach agreements is, are they competing for the employee's labor? And so if you could have two different companies in completely different industries, but if they're both competing for the labor of a single employee, they're going to be considered competitors under the criminal antitrust law. Jacqueline? So we talked about these types of behaviors that are going to be considered anti-competitive and will give rise to criminal antitrust liability. And the four topics that I think are kind of the most critical topics right now in criminal antitrust are wage fixing, no poach agreements, government procurement, and whistleblowing. These are all things that have had significant developments within the last year or two in criminal antitrust. And we're going to talk about what those developments are and how to deal with those in your company. Jacqueline? So wage fixing and no poach go hand in hand. And this is something that has started during the Obama administration. It started in October of 2016. But it's one that's been continued by the Trump administration. At least so far, the Biden administration indicates, early indications are that they're going to continue to adopt the same kind of policies that the Obama and Trump administration have with respect to wage fixing and no poach agreements. So what happened is in October of 2016, the Obama administration issued some guidance called Antitrust Guidance for Human Resources Professionals. And what this guidance was is it put companies on notice that no poach agreements, naked no poach agreements, and wage fixing agreements would be treated as per se unlawful and would be prosecuted criminally by the Department of Justice. And what prompted this was a major civil case that occurred in 2014 what was happening was there were several Silicon Valley companies, all in different industries, that had agreed not to poach each other's employees. So Apple, Adobe, Pixar, Sony, all of these companies had agreed not to poach each other's employees. And ultimately, the Department of Justice brought a civil lawsuit against these companies. There was a $500 million civil settlement for all of these cases, and then not long after that, the Department of Justice announced that naked no poach naked no poach and wage fixing agreements would be prosecuted criminally. And so, what they mean by naked no poach agreements is that if there is an agreement that is not ancillary to a legitimate agreement, meaning that it would be a situation where you bring in a consultant and there's an agreement that you're not going to hire away the consultant for your own company. That's an ancillary agreement and not considered a naked no poach agreement. But if you simply have an agreement with another company that you're not going to hire each other's employees, that would be considered a naked no poach agreement and would be prosecuted criminally. President Trump continued to adopt this policy. It brought a civil case, again, under civil antitrust laws, against a company called Wabtec. And this was in the railroad industry, and again announced as part of the settlement as a warning shot to companies out there that the administration will continue to treat these criminally going forward in the future. And Jacqueline, next slide, please. And just this year, starting in December of 2020 and following on into 2021, one after the other, the Trump administration brought two criminal cases. The first was a wage fixing case, United States versus Jindal. This was a wage fixing case where several companies, medical staffing companies, agreed to with each other not to pay their staffers above a certain level. And then shortly after that case was filed, the United States brought a no poach case against Surgical Care Affiliates. And this was a gentleman's agreement where amongst the CEOs, it was an oral agreement that they wouldn't hire each other's employees. And in fact, they had instructed their HR staff and recruiting staff not to hire any senior employees from the other companies that were involved in the conspiracy unless they had told their bosses that they were looking for work and their bosses had agreed that they could go to work for these competitors. So next slide, please, Jacqueline. The United States versus Jindal case was particularly interesting because it involved a Medicare staffing. And the Medicare staffing was not important to the wage fixing part of the antitrust case, but it was mentioned prominently as part of the indictment. And I believe the reason why that was is because the Procurement Collusion Strike Force, which the Department of Justice formed in late 2019, which really targeted criminal antitrust conspiracies involving state and federal government procurement contracts. And not coincidentally, the day after the United States versus Jindal indictment was announced, the Eastern District of Texas, where that case was brought, joined the Procurement Collusion Strike Force as part of tracking down and prosecuting people that are involved in antitrust conspiracies and government procurement. And so what the strike force does is it's a partnership between the Justice Department, the Antitrust Division, FBI, and importantly, state and federal agencies that often let bids. And so this includes state bidding offices as well. And the federal government, the Antitrust Division, help train procurement officers at a state and federal level to spot red flags for antitrust violations, and then an investigation can start. So the strike force has been growing since it started in 2019. It now includes over 50 government departments and agencies around the country. And this is a real enforcement priority for the Department of Justice, because the study that the government found was that a third of active antitrust investigations involved government procurement. And so this is something that the administration, the Trump administration, and it appears to be the Biden administration is going to really focus on as part of their antitrust enforcement. Next slide, please. So the trend of antitrust cases that Norman had mentioned at the outset of the program has been trending downward over the last several years. And so there's some concern about why that is. Jacqueline, next slide, please. Congress has taken notice of this and has passed a Criminal Antitrust Anti-Retaliation Act of 2019. And what this does is essentially provide whistleblower protection for antitrust whistleblowers. If they would raise an antitrust claim, a criminal antitrust claim, they can't be demoted, they can't be fired. This will be investigated by the Department of Labor, and the employee can bring a civil action for reinstatement and attorney's fees. Jacqueline, next slide, please. And we'll go ahead and skip this one, Jacqueline. And so, you know, Norman, we've talked about these hot topics and why, you know, this is how, what are the areas that antitrust enforcement is really on fire right now and really hot. But, you know, maybe you could talk about traditionally a little bit how criminal antitrust conspiracies develop and how an investigation gets started once there is a conspiracy that has emerged.
Sure. Well, this is really more for the traditional antitrust cases, and not so much the wage and no poach situations, which are still new, and I think they're going to be hard to uncover. But there are certain, you know, red flags or items that the government knows about, and they focus on those. So one of them is just commodity industries in general. Any chemicals, industries with low barriers to entry. There's a recent pending case in Colorado now involving fixing of prices for poultry, and it's a big case, a 10-defendant case. And so where there are, you know, where things are not differentiated well, and you're supposed to be competing primarily on price, that is a fertile ground sometimes, especially when you couple it with a recession. And where there is a recession, prices are declining rapidly. People get the idea that one way to stop that is to get together and collude as to the bid rigging or on the pricing itself. Another problem area is sales or marketing personnel moving among companies in the same industry. And it's sort of logical. Somebody starts out, they're in one company in the area, they develop expertise, they go to the next company in the same industry, but still retain relationships at the prior company. And so when things go bad or start to go bad, it's very easy to get in touch with people. And you know, you can think about it, if someone has the idea to organize this kind of a conspiracy as something of a virus. So they start at one company, go to the next one, may go to a third one, and all of the companies could end up conspiring to fix prices, again, in that same industry. And that is done often with extracurricular electronic communications. And what I mean by that is they're not using necessarily email, corporate email, but rather with social media being as prevalent as it is, staying in touch, using social media to communicate outside any sort of internal controls that their employer may have to detect and prevent this kind of activity. Another indication is where there are cryptic or coded electronic communications. And you look at somebody's emails and you see in them, what are you going to buy your shirts for? And you're in, a chemical industry. So when you see communications like that, that is another red flag, a warning that somebody might be doing something they shouldn't be doing. And lastly, trade shows where everybody in the same industry gets together, and the one thing they all have in common is pricing or bidding or the things that exactly the government doesn't want them talking about. And indeed, when the government issues subpoenas in criminal antitrust cases, is always on the subpoena, provide all documents relating to trade shows in which your company or your employees participated. Next slide, please. So how does the government get to figure out these kinds of cases and investigate and prosecute them? Well, the first and certainly the most popular is disgruntled ex-employees, people who've seen things, they didn't get treated well on the way out, and perfectly willing to complain to the government. And indeed, even with the antitrust anti-retaliation statute, it may encourage, I think the Congress intended to encourage people, both current and former employees, to come forward with information about criminal antitrust. Another way these things come undone is where there has been a conspiracy in place, but the person who is responsible for it in company A moves on to company B, and that person is replaced by someone who actually is honest. And no one has brought that person into the conspiratorial group and finds out about it and reports it to the appropriate people within the company. And then the company itself, this person becomes a whistleblower, and the company itself can try and self-report and get leniency, which is something that we'll talk about. Another way these things come undone is where a cooperator, in another case entirely, gives up the existence of an antitrust conspiracy that was not previously known to the government. And that happens because one of the requirements to become a cooperator with the government is that you tell the government everything you know about all criminal activity, not just the activity to which you're pleading guilty or the criminal activity in which you're going to testify. And this has come up. And I'll give you an example, not antitrust, but in another context where a gentleman by the name of Mel Weinberg was arrested for dealing in stolen art in Pittsburgh and wanted to plead and cooperate, and did, and indicated that he had been involved in some bribery schemes in New Jersey. And that led Mel to the Eastern District of New York, and he became the star of the app scam investigation and prosecution of congressmen in New York and New Jersey. Another way, and this is similar to a cooperator, is where there is court-authorized electronic surveillance, there can be antitrust violations that are uncovered by way of hearing about them. Now, if you think about it, you cannot legally wiretap for antitrust violations, but you can for mail and wire fraud and a host of other crimes. And if you think about it as sort of the electronic version of the plain view doctrine from law school, if you're listening for wire fraud and the parties start talking about antitrust or fixing prices or bid rigging or securities violations, for example, then you are allowed to use those conversations as evidence in prosecutions for antitrust because they were inadvertently intercepted. And lastly, there is the somewhat self-destructive, unhappy losing bidder who is in a conspiracy, but he doesn't like the way he's being treated, and so decides to report what's going on somewhat to his own peril, perhaps, but will give up the entire scheme. Next slide, please. So that takes us to the antitrust leniency program. Matt's going to explain what that is.
And thanks, Norman. And you mentioned a little bit about antitrust leniency program, and leniency is really an interesting topic because this only exists within the antitrust division. No place else in the Department of Justice is there anything like the leniency program. And what it is that the first company, usually it's a company, it can be an individual, but usually a company, the first company to self-report its involvement in an antitrust conspiracy receives immunity from prosecution by the antitrust division. So if a company raises its hand and comes in and says, I've been fixing prices, I'm really sorry, I want to stop now, and I'm going to tell you everybody else that's involved in the conspiracy, I'm going to cooperate with you completely, and I'm going to tell you about any other antitrust conspiracies I'm in, they will get immunity from prosecution by the antitrust division. That doesn't mean they get immunity from all prosecution because the Justice Department, separately from the antitrust division, could theoretically bring an offense based on this disclosure, but typically that doesn't happen. The Justice Department usually respects the antitrust division's leniency policy and will typically not prosecute. There are what can really be tricky about the leniency program, especially where you have an international cartel, is many other countries, but not all other countries, have leniency programs similar to the Department of Justice Antitrust Division leniency program. And so navigating the foreign governments and navigating those governments that do have leniency versus ones that don't, and self-reporting large international antitrust cartels can sometimes be a little bit tricky. But that's something that is usually the benefits are going to outweigh the drawbacks when trying to decide whether to come in and report as part of an antitrust conspiracy. There are two types of leniency. There's type A leniency, which is the government did not have any information about your antitrust conspiracy, and type B leniency, which is the government had some information about the conspiracy but didn't yet have enough to make a prosecution. And we'll talk about both of those a little bit more later. The real kind of catch to the leniency program is it doesn't provide immunity from civil suits or prosecution by other federal agencies, as I mentioned. But the civil suits can have treble damages and also attorney's fees, and usually there's a class action associated with an antitrust violation. So even if you get immunity from federal prosecution, you may still have to deal with the follow-on civil lawsuits that claim treble damages and attorney's fees. And so, Norman, why is leniency important in terms of your investigation and determining how to handle a potential antitrust violation within the company?
Well, it's explained on the next slide. So, what you have to do is conduct a quick and yet as thorough as you can investigation to decide whether, whatever the source is for the allegation, whether in fact there has been potentially unlawful conduct. And it's important that that be done with under attorney-client privilege, usually by outside counsel. And the purpose is to give you some breathing space. You are conducting the investigation on behalf of the company. But once the information is uncovered, you have to make a decision on what you're going to do. I mean, one perfectly a legitimate option is not to report and to see whether anything develops and to sort of roll the dice. And if you've been under attorney-client privilege, that's fine. Another aspect of it is that if you are dealing in an international cartel possibility, you need to deal with your subsidiaries overseas because attorney-client privilege, corporate attorney-client privilege is different in different jurisdictions. Some don't recognize it at all. Some recognize it only partially, and some recognize it completely. You have to be careful on what you're doing when you start dealing with the overseas aspect. But it is important not to be doing this in a way that the government can find out actually what you found out before you're ready to disclose it. And therefore, time is of the essence, because if you're looking into a criminal antitrust possibility, it could well be that that others are also looking into it. And to illustrate the point, going back about 20 years, there was a high-profile antitrust investigation involving the auction houses Christie's and Sotheby's. And Christie's found out that there was a price-fixing conspiracy at the highest levels and conducted an investigation, and its lawyers brought it to the Justice Department, and Christie's got amnesty. Not from the civil case, which they paid a lot of money, but they did get amnesty on the criminal side. Sotheby's did not. And Sotheby's ultimately pleaded guilty. Its CEO was convicted after trial. And the story is that Sotheby's went to report the conspiracy one day after Christie's, and they were denied amnesty, and Christie's got it. So once you have figured out something is going on, you really don't have a lot of time to deal with it. And you either have to decide to keep it quiet or get it over to the government and try and get leniency. Matt, next slide.
Yeah, and so practically how this works as part of the leniency program is that you don't need to have all the knowledge about every detail of the antitrust violation before you can, and before you really need to make your decision to seek leniency. The Antitrust Division has what's called a marker. And the marker is that once you have kind of wind of an antitrust violation, you can call up the Antitrust Division and say, I'd like a marker. And then you report some information about your potential antitrust conspiracy. What evidence you have of it, that could be a whistleblower, the nature of the conduct, the product at issue, and typically the identity of your client. And so that's not always the case, but what they like to do is ensure that they have enough information in order to determine whether or not anyone else would be ahead of you in line for leniency. And so the kind of quick and dirty investigation that Norman was talking about is very important, because if you make the decision to try to seek leniency, it's important to get in early and get that marker. And then after you have the marker, next slide, please, Jacqueline, then you can conduct a more thorough investigation. And Norman, what would that consist of?
Well, I would be the same for antitrust as for any other internal investigation that of great significance to a company. So the first thing that has to be done is to secure, preserve, and review electronic communications and documents. Now, you're not going to be able to review all of it, but you're going to have to get through it, as much of it, to get a handle on what it is that you have that you're going to now present to the government in order to obtain the ultimate leniency determination. You need to sit back and plan witness interviews. There is a logic to this. You generally start at the bottom and work your way up. And that, of course, can raise some particularly ticklish issues if the evidence that you're uncovering leads to the C-suite. And then, of course, you have to conduct the interviews, do them quickly, and get the memos done, and try and analyze what it is you have in order to make that decision. Now, as you're going along, you are asked to communicate regularly with the government to give them status reports, because now you've put in your marker, and they want to know, yesterday, what it is that you have uncovered, because whatever you're uncovering is going to make their life that much easier. And as I mentioned earlier, in connection with having things come up, once you have made the decision to seek the marker, you must fully cooperate with the investigation that the division starts to conduct, and you should be taking steps to secure employees' cooperation. Now, that, you cannot make an employee waive their Fifth Amendment privilege, but there are various ways to try and persuade employees to come forward, and they can sometimes be protected by your umbrella of leniency if they do. Matt? Next slide, please.
Next slide, please, Jacqueline. So we're going to kind of run through these kind of quickly. We've already talked about the types of leniency. There are two types of leniency. They really, in terms of the results, don't differ a whole lot. But the type A leniency is where the division has not received any information about the conspiracy at all from any other sources. And type B leniency is where the division has some information about the activity from another source, but there isn't enough information for the division to secure a conviction. And so in either instance, you can potentially be eligible for leniency, but you may have to go a different route depending on the facts of the case. Next slide, Jacqueline. One of the things that Norman talked about uncovering antitrust conspiracies is the Leniency Plus program. As part of Leniency Plus, you get reduced sentencing credit on, which is essentially a reduced criminal financial penalty, if you report your involvement in a separate antitrust conspiracy. So company comes in, reports one antitrust conspiracy, but usually sometimes, at least when there's one, there's more. And they say, not only am I fixing prices in product A, I'm also fixing prices in product B. You get a 2-for-1. You get a freebie, and you get reduced sentencing credit reduced criminal penalty on both antitrust conspiracies. And then you would also then snitch on two separate conspiracies partners in product A and product B. The flip side of Leniency Plus is if you don't report the other conspiracy, you get a double whammy. The last issue that is not exactly leniency, but the Antitrust Division has just recently announced that it will enter into deferred prosecution agreements if a company has an effective antitrust compliance program. That's a policy change until 2019. The Antitrust Division would not enter into deferred prosecution agreements. It would only accept guilty pleas. But so in order to qualify for a deferred prosecution agreement, you have to have an effective antitrust compliance program. Next slide, please. So to take away, what you need to do for an effective compliance program is it needs to be well-designed, actively applied, and detect potential problems. And what practically that means is that it can't just be a paper program. There has to be a commitment to compliance from both the top, and increasingly now, tone at the top is a buzzword that was popular a few years ago. Increasingly the buzzword now is tone in the middle. What are the middle managers doing to ensure that compliance is part of a company's day-to-day operations? If you have all three of these, you can qualify potentially for a deferred prosecution. Next slide, please, Jack.
Yep. We're almost done. I just wanted to finish this portion of our presentation with two ideas or two thoughts. As Matt said earlier, the antitrust leniency program is unique, and as you see, there's has its own vocabulary about type A leniency, type B leniency, leniency plus, markers, and you really have to ask the question, why is it that the Antitrust Division is the only division in the Justice Department that has this policy? And it goes back to this belief that because conspiracies are by nature secret and hard to uncover, that there has to be inducements to get evidence to be brought to the government so the government can prosecute the cases. And it's not clear to me that antitrust is unique in that regard. I mean, organized crime keeps its conspiracies secret, and most other criminal conspirators don't advertise. So it's a little bit odd that the Antitrust Division is the only one that has this. And secondly, and this is really across the other parts of the division or other areas we've talked about, export controls, FCPA, environmental, and antitrust. There are really three things that companies ought to be doing to mitigate the problems that happen when they find out, when the general counsel finds out, or internal audit finds out that there are potential criminal offenses. And that is, the first thing that has to be done is to self-disclose. The second thing is to cooperate fully with the government. And the third is to promptly remediate how the problem developed and make sure it doesn't happen again. And following those three things, either specifically with the Antitrust program or in other parts of the Justice Department, can help mitigate the harms that the company is going to suffer. So with that, Jacqueline, do you have another slide after this, or do we go right to? Nope, no CLE credit yet. Okay, Matt and Stephen, it's all yours.
Thanks, Norman. So we're going to shift gears a little bit, and I'm going to talk about trade secret theft now and managing the risks of trade secret theft. And I want to introduce my colleague, Stephen Bloch, on the line. He is a former federal prosecutor out of the Northern District of Illinois, and also, I believe, a state prosecutor as well, Stephen?
That's right, Matt.
Okay, great. So Stephen has a lot of experience from the prosecutorial side of things, and we're going to have it's going to be follow a similar format to where we're going to talk a little bit about the trade secret law from a background perspective, and then Stephen and I are going to talk kind of about what the prosecutorial priorities are with respect to trade secret theft, and how to manage the risk of trade secret theft, as a company right now. This is a hot issue for a lot of companies right now, and it's certainly something that's in the news. We're seeing a lot of articles about trade secret theft in the New York Times, the Wall Street Journal. It was certainly a priority of the last two presidential administrations, and it seems to be the current administration, the Biden administration, is also focused on trade secret theft and how to protect American companies from losing valuable intellectual property to theft. And so as part of this kind of shifting view of trade secret laws, where it's increasingly within the last 2 decades becoming a federal issue, traditionally the theft of trade secrets was governed by state common law, or a little bit more recently by state statutes called the Uniform Trade Secret Act. And if a company had a trade secret theft, they were left to rely upon state law in order to find a remedy for that. And it was exclusively a civil remedy. You could go to court and get damages for the theft of the trade secret. But starting in 1996, Congress began to realize that the state common law was insufficient, that there were real risks and national security risks and risks to the health of the country by an increased trade secret theft. And so Congress passed the first federal law to deal with trade secret theft, and that was the Economic Espionage Act. This was a criminal statute to where if a trade secret was stolen for the benefit of a foreign power, then the federal government could come in and prosecute that case. That didn't create a civil remedy for companies. That was still left to state law, common law, or state statutory law. But there was at least a criminal option for the government to pursue if they thought it appropriate. Next slide, please. But Congress has continued to develop the law in this area on a federal level. And in 2016, Congress passed the Defend Trade Secrets Act, which was really a sea change in how the federal government and Congress looked at trade secret law. And what it did is it created a federal cause of action for theft of trade secrets. It's a civil federal cause of action, and also a criminal cause of action in the federal courts that includes legal immunity for whistleblowers. This was part of a belief that after 20 years, Congress had realized that the Economic Espionage Act wasn't strong enough. It wasn't doing enough to give the prosecutors and also companies the tools it needed to combat trade secret theft. And so it wanted to increase companies and the government's ability to put a stop to trade secret theft. Next slide, please, Jacqueline. So the trade secret theft remains an enforcement priority, and there's been a lot of prosecutions over the last couple of years involving trade secrets, and there's continued legislation that's been introduced in Congress to try to protect trade secret law, such as the Protect American Intellectual Property Act. It received bipartisan support in the last Congress, but wasn't enacted. It's likely going to be enacted in a future Congress. But Stephen, as you look at some of the prosecutions that we've seen over the last couple of years, what does that tell you as a former prosecutor? What the enforcement priorities are with respect to trade secret theft?
Thanks, Matt. What we've seen over the past 2.5 years and really continuing into the current administration is that the priorities of the government really are heavily focused on China. About 2.5 years ago, the government launched a program which it calls the China Initiative. That's the name that the Department of Justice gave it, which is really designed to combat what the government perceives as a sustained effort by the Chinese government to steal American trade secrets. So that's really where we've seen the focus. And we've seen cases brought that involve all sorts of different industries. Sometimes it is high tech, really cutting edge technology, but it also involves medical technology. It involves agricultural technology. It involves manufacturing technology. So it does not necessarily have to be cutting edge. Now, we've put up on the slide here just a couple examples of cases that the government has brought to show the sort of the scope of the industries and the type of cases. There are many other examples, but it's noteworthy here that the government is not simply focusing on Chinese nationals. It's focusing on American-born individuals as well. One very well-known case is Charles Lieber, who is a Harvard professor in the chemistry and nanotechnology field, who was not charged with trade secret theft per se, but was charged with failing to disclose his ties to the Chinese government, to a program the Chinese government has to fund scientific developments on certain forms, and not disclose the payment he received for that. One thing I think is noteworthy to show the focus of the government is that the government has announced that it has trade secret investigations involving China in all 50 states and at least 71 institutions around the country. I personally think there might be some element of puffery going on with the government's numbers, perhaps for political reasons, but also to try to invoke some sort of deterrence. But as recently as last week, the government announced, the DOJ announced that 80% of all economic espionage prosecutions brought by the DOJ involve conduct that would benefit the Chinese state. And they also said that 60% of all trade secret cases, they believe, have some nexus to China. So that's really where the priority is. And Matt, you mentioned the law that was introduced, the bill that was introduced in Congress in the last term, the Protect American Intellectual Property Act. That did get bipartisan support. It did pass the Senate unanimously, which, as we all know, is unique in the current environment, or at least unusual. It did not pass Congress or was signed last year. But what that law really does is it tries to arm the government with additional tools, mostly involving sanctions and mandatory reporting by the executive branch to target foreign trade secret thieves. So that's really where the priorities are. But I think what's the important takeaway is not just what the department's priorities are, but that there is a very real risk. As I mentioned, I think that the government, they are very public about their numbers, and I think there is some element of politics to it. But at the same time, I think this is a real risk to companies and medical centers and universities. So it's really important that the companies identify their sources of trade secret theft. Next slide, please. So Matt, do you want to talk a little bit about, keeping in mind the threat that the government is telling companies, individuals out there, what the threats are to companies and how they can be categorized?
Yeah, so there are, you really need to do kind of, each company is going to have different threat sources. And so as part of developing a program and a plan to protect your trade secrets, and that's one of the themes that we're going to talk about during our presentation today, is the need to have a plan in place to protect these trade secrets, that the company really needs to understand and where its risk is coming from, and to do a risk assessment to say and determine where is the risk of loss with respect to my trade secrets. And so we have some on this slide, some common areas where you're going to have some risk, either through your employees or insiders. You have employees who are disgruntled and decide that they're going to take some trade secrets when they leave the company because they think they've been treated unfairly, or they've been treated badly. They haven't been paid enough, and so they feel like they deserve some more money for their hard work, and so they're going to take a trade secret and sell it to a competitor. You have employees that are just greedy about wanting some more money, and they maybe have been approached by a competitor or a foreign actor who is willing to pay them a lot of money in some cases to provide trade secrets to them. Or so your own employees could be a source of risk for trade secret loss. You could have hackers. This is something that has been in the news lately with the SolarWinds prosecution, or not prosecution, excuse me, the SolarWinds hack that affected the United States government, where hackers were able to log on to computers and receive and get access to sensitive documents, including documents in the court system. And so hackers could be a risk that your trade secrets could be lost if they're kept on a computer network. Foreign governments. A lot of times, foreign governments are working in tandem with these other types of people, either with insiders or with hackers, to fund them or to provide money to buy trade secrets. Or sometimes when you have joint ventures or teaming agreements. As part of a lot of these teaming agreements, you may share technology with your partner on a teaming agreement or on a joint venture. And so your trade secrets may be at risk through a program where you think this is going to be productive for you. You've entered into this joint venture with someone to make a lot of money, and what ends up happening is that your trade secrets end up being compromised as part of the process with the joint venture. And so these are four kind of common areas where you might see a risk of loss from the trade secrets.
And Matt, I just wanted to touch on a point that you raised. When you have these four potential sources of risk, as you sort of said, they don't operate in a silo. I think it's important to note that there can be, and often is, we're seeing in these cases brought by the government at least, a lot of overlap between these sources of risk. So I think it's important for the compliance officers on the line, or the general counsel on the line, that if you sort of think, well, a foreign government targeting my trade secrets sounds like something from a spy novel, it seems really unlikely, that you should probably pause and think again. There really are many instances where employees or insiders are given incentives by foreign governments or by universities in foreign governments, associated with foreign governments, or companies overseas funded by foreign governments to steal your trade secrets. So there's a lot of overlap between these, and really any company medical center university with trade secrets does have some vulnerability here.
Well, and Stephen, that goes back to the Charles Lieber case at Harvard, right? To where he was accused of receiving funding from the Chinese government to work on research that wasn't disclosed. With the implicit premise, right, is that the Chinese wouldn't be funding the research unless they wanted the results from it.
That's right. That's right. The Lieber case is a great example, and there are others. It doesn't have to be so clear as an individual walking out the door with the technology in a box or on an SD drive. It could be that they're just incentivized to work for a foreign power or a university or company associated with a foreign power, and that through that process, the technology might be transferred over time. I think that's why, as I understand it, the government was focusing on Lieber. It wasn't because they had information that he had stolen a specific trade secret. It's because the failure to disclose raised significant concerns that he either had done it or he was going to do it in the future. So let's go to the next slide, which is involving how the risk of theft. Now, a lot of things might be somewhat obvious about having confidentiality agreements in place, making sure that your confidential information is protected, the real property, identifying what it is and making sure it is segregated from other company information, limiting access to it, of course, to those who need the information, and having policies in place. Now, I did want to pause, Matt, there. You know, we've all gone through a very challenging year now, and many of us, as we can see from the webinar here, are working remotely. What impact does this remote work environment that might continue have on a company's ability to mitigate these risks? And what have you been advising clients of how to handle the remote work environment vis-a-vis protecting trade secrets?
Yeah, I think, Stephen, it's been a huge impact to companies that we're going to see play out over the next few years, where, you know, when the pandemic started a year ago, you know, companies at that time were really moving 100 miles an hour in figuring out how they were going to continue to have their people working. You know, getting computers to people, making sure that they had, you know, remote connectivity, making sure that people could literally function in their jobs at home as opposed to being in the office. And I don't think a lot of attention at that time was really paid to figuring out how companies were going to continue to protect their trade secrets as part of this shift to remote work. But, you know, what we've seen now is that there are a lot of companies, I think, that are making the decision that, you know, we can have people continue to work remotely after the pandemic is over. And so I think we're going to see a shift in, you know, people working from home more frequently. And that's no secret. But what companies need to be really cognizant of and thinking about is, how am I going to continue to protect my trade secrets when I have people that in a building that I can't control working from home? And that's a real tough issue. You know, you talked about securing real property, and you know, so a lot of companies have businesses where you have a swipe card to get in. You have a locked file cabinet where you keep this sort of stuff. You have, you know, codes you have to punch in to get to the secure room that contains the top secret files. But when people are working from home, they don't have any of that. And so how do you control the employee from, you know, printing out the trade secret at his house and leaving it on his desk? And then someone walks in, maybe a neighbor, or, you know, he has a party and somebody's, you know, wandering around at the party and, you know, poking their nose where they shouldn't belong and seeing information out, you know, sitting on a desk that may be a trade secret, a very valuable trade secret for the company. And so, you know, thinking about IT policies of how to protect that information. what does that look like? Are employees able to even access trade secrets at home? Maybe as we move away from the COVID environment, there's limitations on ability to work from home if an employee has access to to really sensitive trade secrets, or on those days that the employee needs to view the trade secret, they need to come into the office, or all computers need to have USB ports locked down. You need to have, prohibit the use of external hard drives. These are all things to think about, and the answers are going to be a little bit different for each company, because how each company looks at its trade secrets. I mean, some companies may have lab formulas that are trade secrets that are going to be treated a little bit differently than, maybe software programs that could be a trade secret. But really thinking about how to manage those trade secrets and manage access to those post-pandemic is going to be critical for a lot of companies, especially where employees are working remotely.
Matt, and I think that it is such a complicated question, and it raises so many issues that have not had to deal before, frankly. And going back to what I said before about not being complacent and thinking it can't happen to your company, sure, on one hand you might say, the piece of paper with a trade secret on a desk in someone's house, the chances of a neighbor seeing it who might know what it is, and maybe that's low. I guess it depends, right? Doesn't it depend on what is the trade secret, what is the industry, who has access to the home? But the technology is what I find particularly interesting. Most of us have work computers or laptops we're using. Maybe there's a VPN or other dedicated link to our business's network. But many of us use, for example, personal printers. I know I have a personal printer at home, and as I understand it, if you print a document using your printer, there very well may be some record of that in your printer, depending on the software and what it is. And that printer is on a network, and that printer is on my home network. So you're giving up a lot of control and a lot of trust to your individual employees, where there could be inadvertent disclosures or actual intentional disclosures. So it's a real issue.
It is, and it is. I think you're right that it depends on the nature of the trade secret, because one of maybe the most famous trade secret of them all is the 11 herbs and spices from Kentucky Fried Chicken, and this has probably been about 2 or 3 years ago now, but supposedly the 11 herbs and spices were published by a newspaper because they conducted an interview with a woman who was supposedly, I think now she was the former wife of Colonel Sanders, and she had his original recipe in a scrapbook that she showed to a newspaper reporter, who took a picture of it and then published it in the newspaper. And so if you're inclined, you can go out and Google it on the internet. It's now there out on the internet. Because somebody had this thing laying around in a scrapbook, and then a reporter took a picture of it. Now, Kentucky Fried Chicken, of course, came out and said, no, this isn't the real original recipe. Ours is still secret. But nevertheless, it was supposedly Colonel Sanders' own handwriting, and it's out there now because of an interview that somebody did by a person that I'm sure the company wasn't even thinking about it at all as a risk to their trade secret.
So let's move to the next slide, Jacqueline. And we talked a little bit about this. Let's move to the next one as well. So we've talked about what the threat is. We've talked about where the risk is. And of course, the question is, what happens despite all your plans if you suspect that there has been theft of a trade secret? And I guess the first thing I would say about that is you have to have a plan. The worst time to figure out how you are as a company going to react to a potential theft of a trade secret is when someone walks in your office, an IT person perhaps, an HR person, and says, we've got a serious problem here. If you're thinking about it for the first time then, it's going to be very difficult to be nimble enough to react, because these situations move very quickly. So just as your company is going to have a plan to get employees out of the building in a fire, you need to have a plan as to what to do when there is suspected trademark theft. And so, Matt, I know you do a lot of work in counseling clients on how to handle these issues. What are some of the most important things that you could tell people about what to do to develop that plan and how to execute on it?
Yeah, so as part of that plan, you want to have some defined steps, a checklist that you're going to do in the event that someone, like you said, Stephen, walks into your office and says, we've got a problem here. And the first thing on that checklist is going to be identify the property that was stolen and make a damage assessment. Is this, is the trade secret the lifeblood of the company? Is it the 11 herbs and spices, or is it something that is really, really critical to the company? Or is it maybe a trade secret that while important is not going to be a existential loss for the company if it walks out the door? And then as part of that assessment, that's going to influence then your next steps in the process. But as part of those next steps, you need to secure evidence. And that's going to be an electronic hold on your information in your computer. Stephen, you talked about the printers and the record of what people were doing with the printer. This is exactly the type of information that you want to make sure is preserved and locked down. The emails need to be preserved and locked down. Things that you may not necessarily think of, that like key card swipes in and out of the building. Who was coming in and out of the building and during the times where the trade secret was at risk? Who was entering into secured areas? If your trade secrets are in a secured lab, make sure you preserve the card swipes that allow people in and out of that lab. Parking, if you have a secured parking lot, to preserve who was driving in and out of the parking lot. And then a chain of custody, because you got to be thinking about right away, if this goes to litigation, civil or criminal, you need to preserve that chain of custody, because the evidence, Stephen, is going to be very important as part of to the government if you choose to go criminally or in a civil case.
I think that's right. And we'll talk a little bit more about that civil criminal component in a moment. But I'll tell you, as a former prosecutor who did get the phone calls after a company suspected trade secret theft. One of the first questions that the prosecutors and agents are going to ask about is chain of custody. If you could have collected some really powerful evidence of theft, but if you can't trace it back to where it came from, you can't explain its provenance, it's of very little use to the government. And Matt, I know you and I have seen that in cases that we've handled where we had on the defense side now had some pretty serious questions about where evidence came from, and it could really make it difficult to proceed with one of these cases. Let's go to the next slide, and we're going to talk a little bit about conducting an investigation after you suspect trademark theft. And I'm pretty curious, Matt, about the first one. It came up in your talk with Norman about antitrust, which is determine whether the investigation should be privileged or not. In other words, should you be using outside counsel to come in and help with the investigation, or should you be relying on people internally at the company to look into it? And what you and Norman talked about was when you have a privileged investigation, it can remain, at least in the US, it can remain secret. You don't have to report it to the government or to anybody. Now, we don't have leniency in these trade secret cases, of course, so I'd be interested to know, what do you advise clients in terms of why an investigation should or shouldn't be privileged in the trade secret arena?
Yeah, and I think it goes to the value of the trade secret that's at issue here, and where you see the litigation going into the future. And if this is going to be, if you're certain there's going to be civil or criminal litigation, you may want to think about having a privileged investigation, because what you find and what you gather as part of that investigation, if it's not privileged, is going to be turned over to the defendant in either the civil or criminal case. And there may be situations where you don't necessarily want the defendant to know kind of how the sausage was made, so to speak. Because not to say that you're doing anything improper, but there are situations where I think you want the ability to conduct the investigation without kind of prying eyes, second guessing everything you were doing, and then be able to bundle it all together along, say, and say, here are the results of our investigation to either the government as a prosecutor or ultimately in a civil case to the jury. And you want to be able to do that without somebody coming in and saying, what about this and this and this and that? And why did you ask these questions and not those? It can be a difficult situation where ultimately in the end you're going to end up in a courtroom. But what about, Stephen? You've interviewed a lot of witnesses as part of your time as a prosecutor. What are the things that you want to keep in mind, or the company should keep in mind as they interview witnesses and conduct exit interviews of potentially a trade secret thief? How do you handle that kind of situation?
Right. And it can be difficult because, again, these situations move very fast, which comes back to having a plan in place and identifying, I think, before there's an issue, who are the people either at your company, if it's going to be done internally, or who you might rely on outside the company to be involved in these interviews. Interviewing effectively is a skill. It's an art. It is kind of honed over time, and there are certain rules and certain strategies that are used by good interviewers. And so what you don't want to do, Matt, is you don't want to do it on the fly. You don't want to task an HR person who might not have the training. Now, of course, some do have the training, but you don't want to task someone who doesn't have the training to go and do an interview of a potential trade secret thief, a potential criminal defendant, or a potential defendant in a case that the company may bring without having training. You also want to, of course, always make sure there's more than one person in the interview. There's some, nuts and bolts issues like that. But you also want to have these other issues resolved ahead of time in terms of gathering documents, gathering evidence quickly and efficiently. If you're going to do an interview or attempt an interview, ideally the interviewer already has a host of information about what they believe happened to arm themselves going into the interview. If they go in cold and are just fishing, it's not likely to be effective. So I think it really comes back to having the plan in place ahead of time so that you can execute on that plan when the time comes, just as you would with any other significant adverse corporate event.
And one thing to think about too is kind of the final step is, what about insurers? This may be something that is insured, and what you don't want to do is forget, as part of this process, to notify insurers where appropriate. You don't want to be in a situation where you've waited too long and your insurance coverage is at risk because you failed to notify the insurance company of a potential loss. And so, because there is a lot going on, and people are going to come to you with their hair on fire because they feel like a valuable trade secret has walked out the door. People are going to be panicked, and this is why the importance of having that plan to make sure you have that checklist of, what am I doing? What do I need to do here to make sure I'm not missing anything? One of the things on that checklist should be, think about whether there's insurance coverage and whether you need to notify those insurers. Next slide, please, Jacqueline. And so we're getting to the end here, and we'll kind of buzz through the next couple of slides. You can go ahead and skip to the next one, Jacqueline. And so, Stephen, one of the things we've talked about this whole time is civil cases and criminal cases. And so, as someone who's been on kind of both sides of that, so civil and criminal cases, what do you think are the factors that a company needs to think about when deciding whether I'm going to go to the government and ask it to bring a criminal prosecution, or whether that they file a civil lawsuit?
It's a difficult calculation, and it almost always needs to be done extremely quickly. I mean, look, on the criminal prosecution, the company gives up some things by calling the FBI and saying, we believe this trade secret has or is about to walk out the door. Can you investigate? And what you give up is you give up some control over the case. In criminal investigations, and I told people this all the time when I was on the other side, it's really a one-way flow of information. And the information flows from the victims or witnesses to the government. It doesn't often flow in the other direction. Doesn't mean they're not going to be cordial and civil and try to tell you what they can, but oftentimes the government's going to be constrained. They're not going to be able to tell you about upcoming enforcement actions such as searches or arrests. And so you give up some control. A pretty significant issue with criminal proceedings is you might lose more control over the trade secret because defendants have constitutional rights. Should the case go to court, trials are public. Really, most anything the jury relies on to reach its verdict could become public in some way. There's a lot of nuance to that, but it is certainly a risk. And so by going to the government, you potentially lose the ability to control the secret. You also could stretch resolution out for some time. On the other hand, there are situations where the government can do things to potentially protect your trade secret that you can't. The government can search the home of a potential trade secret thief, a former employee, can search their personal computers, can stop them at the border, can do surveillance that you cannot readily do. So there are certainly things that if you think a secret is about to get on a plane to leave the country, there are things that the government could help with that could protect your trade secret in a way that you can't. So it really is a balance, and it comes down to what is the trade secret, how valuable is it, and what you think the likelihood is of getting it back.
Yeah, I think that's right, Stephen. And this is always going to be a fact-intensive calculus as to whether to pursue a civil or criminal remedy. And there's going to be pluses and minuses to each one. But the key kind of takeaway here is you need to think about that stuff in advance, because what's happening, as you've emphasized, is that this is going to be a quick process, and you're not going to have the luxury to sit back and think about what you want to do. And so you develop that plan in advance, start thinking about how are we going to proceed if there is a loss, and what are the steps and factors that we're going to consider and how to pursue that.
That's right.
So thanks, Stephen. I think that comes to the end of our presentation. I appreciate your time. If you have any questions, please feel free to put them in the chat or to send Stephen or me an email. Or pick up the phone and call us, and we'd be happy to talk to you about trade secrets and some of the stuff that we weren't able to get into in this short time. But thanks, Stephen. And
Thanks, Matt.
I should say also we do have a tracking code. This is the first CLE tracking code, so this is critically important. It's March CLE. That code is March CLE.
And Matt, that's not a trade secret, right?
That's not a trade secret. Don't share it with your friends, but that one's not a trade secret. So I'm going to turn it over now to John Mitchell and Sarah Hall, who are going to talk about healthcare fraud. John?
Thanks, Matt. And I appreciate giving the CLE notification code when you did. That is an excellent way to grab everybody's attention right before we start the presentation. Today, Sarah Hall and I are going to talk about examining trends and developments in healthcare fraud and prosecutions and investigations. I'd like to start by giving a brief thank you to Brian Steinwasser, who was really integral in putting this presentation together, and of course to Jacqueline Chavez, who does a very good job of herding the cats and keeping us all organized. And when we talk about healthcare fraud, I'd like to start with just a very basic fact. On March 11th, 2021, President Biden signed the $1.9 trillion COVID relief bill. Now, I attended a white-collar seminar about 10 years ago, and the subject, or at that time, it was TARP, which we might remember was a $700 billion government bailout was passed, and I heard one of the administrators of that program speaking to a room full of white-collar attorneys tell us that he estimated, or the government estimated, at any major program like this that they would encounter 5 to 8% of the total amount would be fraudulently used. So the many white-collar lawyers in the room collectively exhaled together because 700 billion is a lot of money, but 1.9 trillion even trumps that. And it should come as no surprise to everybody on this call when the government spends significant amounts of money that oversight, regulation, investigations, and prosecutions are most certainly going to follow. And today what we're going to talk about really is a very broad brush discussion of what is healthcare fraud and kind of what the universe looks like in terms of what sorts of actions may be out there, what your organization may be facing, the way that these cases are organized and brought and presented to grand juries, just to give you an idea of really what the universe of healthcare fraud looks like. We hear it all the time. We see it all the time on the news. But what is it in a general sense? It just really is fraud involving healthcare plans that are both public and private. And there are two sets of statutes that the government traditionally employs in order to pursue these types of these matters, one of which even has a component that allows the public to participate. The first is the False Claims Act. It's a civil statute, and the FCA, believe it or not, was passed during the Lincoln administration, and that was originally put in place to combat fraud, defense contractor fraud during the Civil War. Notably, for our purposes today, and what usually grabs everybody's attention, is that it involves a treble damages component and also allows for private individuals to intervene, as I'll discuss later in our presentation. Also significant is the Stark Law, and that prohibits physicians from participating in self-referrals to entities where they or their family members have an interest. This also contains a treble damages provision, but more importantly than that even, this allows Medicaid to exclude violators of the Stark Law from participating in the Medicaid program, which you can imagine would be a tremendously draconian penalty to an organization that was primarily dedicated to treating sick people. There are also some significant criminal statutes and penalties involved in healthcare fraud as well. The anti-kickback statute at its heart prohibits an exchange or an offer to exchange anything of value in an effort to induce or reward the referral of business reimbursable by federal healthcare programs. Additionally, healthcare fraud is right on the books in 18 U.S.C. 1347, and at its heart, it prevents defrauding healthcare programs or obtaining by fraudulent pretenses, representations, or promises monies owned or controlled by a healthcare benefit plan. And in 1349, accompanying that statute, criminalizes attempts or conspiracies to engage in healthcare fraud. And lastly, when the government, if they find themselves facing a set of circumstances that just doesn't fit into either of those boxes, can always go to the tried and true mail and wire fraud statutes captured in 18 U.S.C. 1341 and 1343 respectively. And that, of course, criminalizes using a scheme or an artifice to defraud, or presenting using false or fraudulent pretenses or representations or promises to obtain anything of value in the commission of an offense. Next slide, please. No question that treble damages typically grabs everybody's attention, but it's important to recognize that the criminal penalties for these crimes are significant and they accelerate very, very quickly. For example, a violation of the anti-kickback statute is punishable by up to 5 years in prison, 10 years for a healthcare fraud violation, and 20 years for a mail or wire fraud conviction. But importantly, when you think about a potential threat to liberty, it's important to think about the effect that this behavior would have on the computation of a guideline sentence under the United States sentencing guidelines. And it doesn't take a whole lot of activity here, or even a modest crime, to accelerate the potential risk to one's liberties. And if you start in looking at this guidelines offenses under these statutes, typically you start at a 6 or 7, which is near the top of a Zone A or a probationable offense, and then the loss amount dramatically increases the sentence exposure. For the example we've provided you here today, $500,000 in fraud, which again would be a very modest healthcare fraud case brought by the United States Attorney's Office would result in a potential sentence of from 27 to 33 months in a Zone D if the government decided to pursue, if the court decided to pursue a guideline sentence involving a particular individual. Now, I bring this to your attention because, as Norman discussed, I've defended these cases, and I've sat in court, and I've tried these types of cases, and Sarah Hall has prosecuted these types of cases. So you can see very quickly how the stakes rise, how they become extremely important, not only to individuals facing these sort of charges, but also to organizations as well. And could you turn the slide, please? Thanks. So one of the buzzwords we heard today a couple of times is compliance, compliance, compliance. And you cannot stress that enough in today's environment, particularly if your organization is facing what we call unwanted government scrutiny. All right, and if you go to the Justice Manual, if you've got time and nothing better to do here in our quarantine environment, you can go to Chapter 9-28.300, and that walks through the Phillips factors and what the United States Attorney's Office and their able AUSAs are supposed to analyze when deciding whether to charge a company with criminal liability. And, they talk about things like the nature and the seriousness of the offense. They talk about the pervasiveness of the wrongdoing within the organization. They talk about the corporate history of misconduct. They talk about how a corporation is willing to cooperate, that was addressed by Norman and Matt early in our presentation. But twice in the Phillips factors, they talk about compliance, and they look specifically at the adequacy and the effectiveness of the corporation's compliance program. And if they discover that there isn't a significant compliance element to this entity, they immediately defer to the corporation's remedial efforts to implement an adequate and effective corporate compliance program or to improve an existing one. And I bring this to your attention because if you're in the healthcare arena, and with the way that federal criminal law works, your employees and their actions can have significant effects on the way that your company is treated should there be a healthcare fraud scenario. And it's important, vitally important, that your organization have a strong compliance program, and frankly, that is almost the price of admission to participate in the healthcare system today in the United States. Additionally, just to think that we're not going to be ignoring individuals as well, the Phillips factors in the United States or the Justice Manual make it clear that these investigations are to prioritize high-level corporate officers regardless of how a corporation is treated. And for your purposes, that will have the hopefully beneficial effect of having a strong compliance program can really demonstrate that we're dealing with a rogue actor in these types of situations, and then the company can go on its merry way while the government more appropriately focuses on the wrongdoer in these situations. Could you please turn the slide? Well, the False Claims Act is something that I'm sure everyone's familiar with, and it talks about civil and criminal liability, and specifically that we expect to see significant action in the near future in the healthcare fraud arena. And under the False Claims Act, there's a component called a qui tam action that I'll address in a moment. But it's interesting that in terms of long-lasting legislation that's proved beneficial to the United States, I think it's worth repeating that this originally was passed during the Civil War and was designed to combat defense contractor fraud, but has really spiraled out and become almost its own legal discipline. Under the False Claims Act, in the civil context, a claim is a request or demand for money. It can be any request or demand, whether under a contract or otherwise, for money or property. It can be made or caused to be made, meaning that it knowingly presents or causes, or knowingly, causes to be presented, is something that can be established as part of the False Claims Act claim. And we put this in here specifically to tell you that the mens rea is not very challenging under these cases. You have a knowingly element, but then you can bring a claim under the False Claims Act that stresses deliberate ignorance or even is premised in reckless disregard of the statements made to the government, or underlying those statements, the documents that were used to present a claim to the United States of America. As I mentioned before, there are treble damages. There are significant whistleblower provisions that I'm going to talk about in a moment. And then there is a lengthy statute of limitations and tolling periods that the government can employ to make sure they have a chance to truly investigate the amount of fraud at hand here. Next slide, please. Thanks, Jacqueline. So this statute is going to empower whistleblowers, all right? And that's what it was designed to do. And you see these key TAM actions are becoming more and more popular. And there are lawyers now who have dedicated their career to serving as plaintiff key TAM attorneys, locating and identifying whistleblowers who can help them bring false claims acts. And the interesting thing about the key TAM action is that it's brought by a relator who is in this case a private citizen or a whistleblower, and they bring the suit on behalf of the government. Importantly, the relator can only bring an original claim, meaning something that has not had the attention or has not been investigated by the government. But what is significant in that is, as I said before, it empowers whistleblowers to turn in companies that are doing things illegally or in contrary to regulations. And in bringing this, there's a process that's specific and unique to key TAM actions that gives the government to make a determination if it would be fruitful for them to intervene or participate in the suit. Specifically, the process involves a relator filing a sealed complaint that is then served on the United States Attorney's Office and the Department of Justice. And then the government has 60 days to investigate that complaint to determine whether or not it wants to intervene and take over the prosecution of the action, or if they'll leave it to the relator to prosecute the action on behalf of the United States. And it's noted, even without government action, I mean, the relator steps into the shoes of the government and carries the case on behalf of the United States. You know, the government is not only involved in a lot of these cases, but oftentimes will intervene for the purposes of settlement or dismissal if something's appropriate. But what really drives these cases more than anything is the amount of recovery that can take place. And you will see that if the government intervenes, that can be 15 to 25% if for an individual, if the government intervenes, of treble damages, and then 25 to 30% if the government doesn't intervene. And the numbers that are thrown around typically in these types of cases and the treble damages involved really make these lucrative engagements and ones that under the Biden administration we expect to see more and more of in the future. So I'm going to stop there for a second, but before I sign off and turn it over to my able colleague, Sarah Hall, I would encourage you to check out our blog, which is doescrimepay.com, which you can subscribe to, and a lot of the content that you would receive today and other observations we have and analysis of pending legal white-collar issues are there. And we've gotten a lot of positive feedback, and we hope that you'll take the opportunity to subscribe to the blog. Again, that is doescrimepay.com. So thank you for your time today. Sarah, the floor is yours.
All right. Thank you very much, John. Okay. Thank you for advancing to that next slide, Jacqueline. Appreciate it. So my name is Sarah Hall. I'm in the DC office of Thompson Hine. As John mentioned, I'm a former criminal healthcare fraud prosecutor out of the fraud section in Main Justice in DC. So here's one of my favorite slides of all times. We get to see the DOJ healthcare fraud unit and all of the strike force locations. So just to sort of take a step back. So John gave us sort of a high level overview of criminal and civil remedies in the healthcare fraud arena. I mean, we can do deep dives on any of these topics, but for purposes of this webinar, we're really just going to give a broad brush, as John said. So John's last couple of slides were focused on the False Claims Act. So now I want to pivot to criminal enforcement. So under some areas, some subject matter areas of prosecution have exclusive prosecutorial authority vested in Main Justice in DC, such as the FCPA. However, healthcare fraud is not one of those types of areas of prosecution. The U.S. attorney's offices around the country can and do bring criminal healthcare fraud cases all the time. That being said, the healthcare fraud unit out of the criminal division fraud section in Main Justice is the biggest exclusively focused healthcare fraud criminal prosecution and investigation office in the U.S. So you see from the slide here that currently, the current statistics that we have, there are 80 prosecutors nationwide who work in the DOJ healthcare fraud unit. That's a lot. And these prosecutors are really subject matter experts. All they do all day long is investigate and prosecute healthcare fraud and related offenses. So that's kickbacks, money laundering, structuring, related financial crimes that arise out of the core of the healthcare fraud case. So they are subject matter experts. They work in tandem with the U.S. Attorney's offices around the country, and the numbers are going up. So we see here in the slide that since 2018, there's been a 33% increase in healthcare fraud prosecutors out of the fraud section. We have, and then looking at this map here, there are 15 strike force locations that the fraud section has established around the country. The source of this map is the fraud section's year in review, which is a report they put out each year. This is from the 2020 version. You can read all about it. It's a publicly available document. It's pretty interesting, actually, and it covers all of the operations of the fraud section, not just the healthcare fraud unit. But to look at this map, so 15 strike force locations. The fraud section has been really busy in adding new locations around the United States over the past couple of years. So just to sort of go from Chicago around, we've got Chicago, which is a fairly new location. Detroit is a pretty established and very busy and active location of the strike force. And then we have the Brooklyn strike force operating out of the Eastern District of New York in Brooklyn, New York. A newer office is the Northeastern Regional, which covers Newark, New Jersey, and Philadelphia. And then dropping down, we see the National Rapid Response Strike Force. I'll talk about that in a minute. That's a little bit different. And then the two black dots represent the Appalachian Regional Prescription Opioid Strike Force locations. That's quite a mouthful, but this is a fairly new, within the past couple of years, project of the fraud section to really try to focus on prescription opioid criminal fraud schemes. So we see the two locations in Fort Mitchell, Kentucky, and then Nashville, Tennessee. And then moving down to the south, there are 3 strike force locations in Florida, Miami being the most established and probably the most active. And we also have Tampa and Orlando, which are more recent and maybe smaller operations. 3 locations in the Gulf Coast, Baton Rouge, Louisiana, which is the middle district of Louisiana, New Orleans, and Gulfport, Mississippi. Gulfport is a newer location. And then moving over to Texas, we've got Houston, which is a big and very active location. There's a lot of healthcare fraud in South Texas and in Houston, and then a couple other locations. Dallas is relatively newer, and then we have the Rio Grande Valley and San Antonio. And then finally, on the West Coast, Los Angeles. So that is the only truly West Coast location of the strike force. So these are the areas that the DOJ fraud section has designated as sort of the hotspots. And the strike force attorneys work hand in hand with U.S. attorneys' offices around the country. Okay, next slide, please. So what have we seen in 2020? So 2020 obviously was a very strange year for all of us. It was harder for the Department of Justice and the investigating agencies to investigate and prosecute due to lockdowns, due to public health constraints, things of that nature. So we see that in 2020, the healthcare fraud unit charged fewer defendants, but for much bigger schemes. So the loss amount per defendant has been increasing really, really rapidly. So there was a 51% decrease in the number of individuals charged in 2020 versus the prior year, but we see this huge ramp up in the average loss amount, or the alleged loss amount per individual, per defendant, since 2018. So 2018, the average loss amount per defendant was 4.3 million. The next year, 2019, it more than doubled up to 11.9 million. And in the most recent year, we have data for 2020, it's $22 million in loss per defendant. So when you think about the intake sort of threshold for the fraud section, healthcare fraud unit, it's going up and up and up. The U.S. attorney's offices typically will focus on sometimes the smaller cases, sometimes big cases too, but the fraud section really focuses on the larger, big dollar cases, and we see that those numbers are rapidly going up. Next slide, please. So for many of you who follow the fraud section, you may know that the healthcare fraud unit typically announces one big takedown per year. So this is essentially a coordinated takedown, as they call it, of arrests of individuals around the country out of all the strike force locations, and then also participating U.S. attorneys' offices. So they typically do one really big one per year. 2020's takedown was pretty big, $6 billion in alleged loss amount total. So that broke down into three big buckets of types of cases. The biggest bucket in the last takedown was telemedicine. Now, that's not too surprising considering that telemedicine has really expanded in usage due to COVID-19. People are at home, they don't want to go into doctor's offices, they want to have doctor's appointments from the privacy and safety of their own homes. There's also fraud that goes along with that too. So the biggest bucket of that takedown was for telemedicine. The second biggest bucket was for something referred to as sober homes. So sober homes these are substance abuse treatment facilities, and typically these schemes involve kickbacks that are paid to patients and recruiters to bring patients into particular facilities for treatment, and then the alleged fraud proceeds from there in terms of moving patients from home to increase billing and things of that nature. So sober homes came in at number 2 at $845 million of the total $6 billion loss amount. And then rounding out the areas, opioids came in at $806 million. There were 345 defendants charged, including 100 licensed medical professionals. There was a really high participation rate. 51 federal districts participated. So that's about half of the U.S. attorney's offices around the country. There are 94 federal districts, so a really high participation rate. Okay, just in the interest of time, let's go to the next slide, please. Okay, so this is another, sort of broad brush area to be aware of. Just prior to the pandemic, in early March of last year, DOJ rolled out what they're calling the National Nursing Home Initiative. It's a joint effort of the Department of Justice and the Department of Health and Human Services, OIG. So again, it was rolled out prior to the pandemic, so it's independent. The genesis and the origin of this is independent of COVID, but it's essentially it's an initiative where the focus is said to be on what DOJ has referred to as grossly substandard care in nursing homes. The initiative encompasses civil and criminal enforcement, and it is expected to receive referrals from your traditional qui tam whistleblowers and False Claims Act cases, but also regular whistleblowers who don't file a qui tam lawsuit. DOJ is expected to look at the wrongful death lawsuits that arise out of deaths in nursing homes, and then the traditional referral source of inspections by federal and state regulators. Obviously their nursing homes were extremely hard hit by COVID, with more than 160,000 estimated deaths in nursing homes as of last month. So, we expect that the National Nursing Home Initiative will look at those particular facilities with high levels of deaths among residents and also professional, the folks who work there, to potentially target those facilities for enforcement under this initiative. Next slide, please. So just going to touch on this briefly. So the CARES Act and liability for providers. I mean, this is a big deal. So the Provider Relief Fund, which was part of the CARES Act, provided $178 billion from HHS to hospitals and other healthcare facilities such as nursing homes and assisted living facilities. The attestation process, whereby the recipients of these funds had to attest to certain terms and conditions, we're looking for that to potentially have some False Claims Act implications in terms of liability arising out of those attestations. So that's something to watch. In the middle of last year, the Principal Deputy Attorney General, Ethan Davis, he gave a speech to the Chamber of Commerce in which talked about False Claims Act liability being looked at not just for providers, but for other Other entities, he spoke of private equity firms who invest in recipients of CARES Act funds as potentially being on the radar screen to the extent these private equity firms took an active role in illegal conduct. So, I think the bigger trend here is to be prepared for this big expansion of the use of the False Claims Act. And that's just one sort of example from last year. Okay, next slide, please. All right, so John touched on the False Claims Act. I'm going to just run through some highlights. So focusing on the Trump administration, a couple of highlights. Obviously, heavy focus on civil and criminal enforcement in regards to prescription opioids. The Purdue Pharma case was a huge one. It was a $2.8 billion settlement by the company, and there was also large settlements by the individual owners. The Indivior case out of the Western District of Virginia, another huge one. This one was related to mismarketing of an opioid addiction treatment drug. So those are two sort of blockbuster cases from the tail end of the last administration. We also saw the, January 2018, Michael Granston, who was at that time the director of the Commercial Litigation Branch, Civil Division in the Civil Fraud section. There was a memo that's been referred to, commonly referred to as the Granston memo. Essentially, it described the factors that DOJ prosecutors on the civil side should consider in determining whether to seek dismissal in cases in which the government has declined to intervene, listing out a number of different factors, really focused on trying to weed out what the Granston memo referred to as, quote, meritless qui tam actions. That's a huge issue, and that will be something definitely to watch to see if that really results in a lot of dismissals or not. But despite the Granston memo, there was year-over-year increases in new False Claims Act cases. So that's obviously going to continue. Next slide, please. Okay, so now we're in the Biden administration. So what's going on with the False Claims Act now? So now we have Deputy AG Granston, who is speaking about the increasing use of data analytics to identify fraud that wasn't uncovered by the qui tam whistleblowers. So, is this really big news? I mean, the use of data to find healthcare fraud, whether civil or criminal, it's really not a new development. That's been going on for a very long time. Crunching and slicing and dicing all of the claims data and all of the other data that's available is a tried and true method in weeding out and identifying cases for investigation and prosecution. So I think that will just continue, and as DOJ and the agencies such as HHS are increasing in their sophistication to mine that data, the investigations I expect to become more and more data driven. And just in the interest of time, can we go to the next slide, please? All right, so COVID-19, we're still in it, unfortunately. Hopefully we'll be moving out of it pretty soon, but what's the impact of COVID-19 as far as healthcare fraud is concerned? Most of the pandemic-related fraud investigations and prosecutions have thus far focused on the use of PPP funds. But as I mentioned before, we're looking to the False Claims Act really being brought in to, prosecute all aspects of pandemic fraud. That is something to be watched, and that's on the horizon. And then the next slide, please. All right, last slide, and then I'll turn it over to Norman. So just looking forward for what's to be expected in enforcement in this year. Obviously, the Special Inspector General for Pandemic Recovery will be watching to see how active that Inspector General is and how closely they can work with other agencies. And of course, Merrick Garland was confirmed as Attorney General. Becerra was just confirmed, I think, just 30 minutes ago, and he will be leading the Health and Human Services. So in both of those both of those cabinet level officials have a long history of interest and work in the False Claims Act sphere. So with that, I thank you for your attention, and I will turn it over to Norman.
Thank you, Sarah, and thank you, John. And the big windup is the second CLE tracking code. It is 3.18 WCC, WCC in caps, and in the earlier one it was CLE in caps as well. And we thank you. That concludes our program, and thank you very much for joining in. Again, any questions, feel free to contact us by any method you feel comfortable. Thank you.